Speaker will be joining soon, will be starting in 5 minutes or less. Please stay tuned. So please turn on your mic.
Is it okay now?
Yes, sir.
Hi, my apologies. I rather mistook it that assumed that it is probably at later time. My apologies for that.
It's okay, sir.
Okay, as this topic pertains to strategies for IPR, and particularly since it's an academic institution, so I'll be focusing on how academic institution strategies has to be adopted to meet the industry requirement in respect of IP. Okay? And this is an open session. I would rather like it to make it more interactive. If at all there is any question or any more clarification you want to seek, please ask there and then rather than waiting till end. And
Excuse me, sir.
Yeah.
Sir, sorry to disturb. Can we just introduce you?
Yes.
And then can we start?
Yeah, rather start right away. Yeah. Yes, please.
Thank you, sir.
Good afternoon to all, and I welcome you all for today's session. And I also welcome Sir for today's session. The speaker for today's session is Dr. Sehgal, sir, and the topic for today's session is Innovation and IPR Strategies in Industry. Sir is a managing partner at Sehgal IPR Services. Sir has over 2.5 decades corporate experience in various functions, which is R&D, regulatory, marketing, and IPR, etc., in specialty chemicals, petrochemicals, polymers, and pharma sectors. He has held responsible positions in big companies. NOCIL started the Royal Dutch Shell-sponsored exploratory R&D activity for the development of potential novel agrochemicals. Sir was at Bal Pharma as a head of regulatory IPR and API marketing. He was at USA IPR attorney in Connecticut, USA, as a training and drafting for patents. He was at Honeywell as a principal scientist and analyst IPR for global IPR services. He was in Jubilant Organisys as a head IPR for API business. And I request Sir to please start with this session. Thank you so much.
Thank you very much. At the very outset, I would like to express my apologies for this delay. And as the topic is innovation and IPR strategies, and this pertains to academic institutions, so I'll be focusing on how IPR institution adopt strategies which primarily is for the industrial development. If you look at historically IPR, is it audible?
Everyone has 16.
Yes, sir, it is audible.
Please start your camera, all of you. It is mandatory.
Hello? Hello?
Yes, sir, you can continue with the session. It is audible.
Okay. I would rather like it to be more interactive so that we can exchange our viewpoints on different aspects which come during we'll be doing the presentation, and also to share each other's knowledge to enrich one's, there's a big repertoire of knowledge in IPR, and we would like to rather exchange among ourselves. If you look back, IPR dates back to this BC era. How it started is a very, very interesting thing, how an innovation happened in everyday life, and one does not realize it. It happened so in a city of governments where people are very, very fond of eating. Some eating places, they were coming out with new recipes, and there was used to be a rush. Others competitors, they used to copy it and giving at lower prices used to attract all the rather potential customer. That is how which was felt that this kind of a concept, this kind of practice in society dissuades innovation among potential innovator. That is how it was thought. We must evolve a process and strategy and policies by which innovation is rather encouraged instead of it discouraged. That is how they said, whatever this community heads were there, they decided we must evolve a strategy. If at all any new recipe for any product is there, then individual or this business person who's responsible for innovation for that should have a proprietary right for a specific period of time. That is how they started, and it said how to name it, how to rather put it under one particular cloud. They rather found out a word from the two Greek words. Monol means alone, polines mean user. Monopoly, that only an individual user. That is how IP concept also was responsible for giving a monopoly word in the English dictionary. That is how it started way back in maybe long before BC time. Now I would like to come to how academic institution. Let me tell you, IP has a value. I would like to guess anyone among audience to guess the price of a 7-star property that is a Taj Hotel, which is in Colaba. Come and guess it. Anyway, let's say about $500 million. Let's say so. Can you imagine IP, one patent in 2004 from the Wisconsin University was sold to a pharma company for $2.4 billion. That is the value of intellectual property. Likewise, there have been many patents which have been sold over $1 billion, particularly in pharma sector and auto sector, by the academic institution. Most of this out-licensing worth billions of dollars have been from the academic institutions to the industry. That rather speaks of what a value an IP has got, which otherwise is probably not realized. Therefore, academic institution must look at it as a source of business vertical, which can really fund R&D to a greater extent and make academic institution independent. This has been proven by the fact in US in particular, you will see products worth $80 billion are being sold in US, which are based on innovations, patents from the academic institution and licensed out to the industry. That is a value. That is the potential of academic institution create IP, which in direct manner assist industry and economy of the country. Similarly, it creates millions of jobs. At institutions also, they have enough funds to hire brains, trained brains, who in turn can create more and more IP. This is basically what IP has got a value and what it is worth for, and role academic institutions have to play in this respect. Now, I would like to touch upon how to plan IP strategy.
Excuse me, sir.
Yes, please.
Sir, are you expected to share any screen because your screen is not visible?
No, last time I had a problem that I could not show the screen. For that reason, I rather decided to have a rather talk, one-to-one manner talk to make it more interactive. You recall last time it was there, is more or less same content, but I am rather looking at it more as an interactive.
Okay, sir, no problem.
Okay.
Please continue.
That's the reason I said, if at all you think there is any question which you need to ask, for which you have to seek a clarification, you are welcome. There and then. Whenever you think of some plan, some R&D project in a particular technology domain, it's imperative to have enough information about that technology, which provides you a lot of information, and that aspect is technology landscape. It is very important to have a technology landscape before you think of or you start a project at R&D level. Technology landscape captures all the patents in that technology domain filed worldwide, and also provides you an opportunity to identify white spaces in that technology domain, which has industrial applicability, which provides solutions to whatever problems are prevailing in that technology domain in the industry. And an expert mind can certainly provide a solution and acquire IP on that and get patents, which has got a ready acceptance in the industries and can be given out for licensing and forms a very good source of revenue generation for the industry, for R&D activities in academic institution. That is the first aspect one has to think of while generating IP. You must think that IP generates patent as a product, and that product should be sellable. There should be ready buyer for that. Otherwise, as you know, IP has lot many inputs in respect of finances, in respect of manpower, in respect of time. All the resources, when put together, combined together, amounts to lakhs and crores of rupees. Therefore, these efforts must generate some product in the form of IP, which has industrial applicability and should have ready buyers for that. That is how one should plan R&D at academic institutions level. For that, as I told you, it is very imperative to have this technology landscape for that technology domain for which you want to undertake R&D activity to develop IP. That technology landscape also gives you a lot of opportunities in respect of ready technology which can be used at an advanced level, as many patents, though published, but either not granted for some reasons or expired as the applicant has not been able to maintain, and that provides a clear base to work from therefrom rather than start it backward stage. These kind of aspects are very important for planning any R&D project, which in turn can result into an IP. Once a technology landscape is developed and is available, R&D experts, they do analyze it deeply, and accordingly, based on the information available to them, they plan their R&D strategies, which can result in a very useful, very productive, and very valuable IP asset. This is the first step you must ensure. Second is, as per the patent law globally, in India too. As you know, in India had signed an agreement with World Trade Organization in 1984 Doha Agreement that effective 2005 patent law will be enacted in India in accordance with TRIPS Agreement. TRIPS Agreement is an agreement which was signed, which was drafted by World Trade Organization, which is a UNO body, which provides the guidelines to all the WTO member states of the globe to comply enact legislation in accordance with the guidelines given therein in the TRIPS Agreement. So India enacted that law in 1995 and made the laws accordingly. As per the patent law, please note, is first to file, not first to invent. Therefore, it is very imperative. It is very imperative to see that your IP idea is not shared with anybody unless and until you have filed a patent application for that. If you have shared with somebody, so on record it is yours idea, but out of friendship and out of curiosity, oh, I have got this idea to work on. This is really, let me share with my friends that I have got this idea, I'm going to work on that. Somebody may steal that idea from you and file patent. And it is the one who first files, not the one who first thinks of or invents. Please make a point of it. Secondly, when in R&D, whatever activity you are doing to develop an idea and to file a patent on that, you must have written records for that. So why this is required? It is not required at the type of filing a patent or during prosecution of patent. For God's sake, if at all at later stage somebody challenges your patent and says, no, this patent is something granted is wrong for some reason, you must have supporting data in respect of whatever document, whatever paper you have submitted with the patent office at the time of filing to support that. And that will be rather required at a court of law if at all, for some reason, unforeseeable reason, matter gets escalated to that stage. Therefore, you must have proper records in your books so that if needed, they can support your invention and patent at later stage if needed. So these are the basic things which you must take into consideration while working in R&D. Thirdly, when you work in R&D to develop an IP, make sure there is one thing which is called enablement. Whatever disclosure you share for filing a patent, that patent must enable a person skilled in the art to practice it. Do not have any idea for which you do not have a supporting experimental data. Therefore, it is very imperative to make sure that whatever claims you are going to have which gets granted, they must have enablement and should not be challengeable later by any opponent. Thirdly, as you know, the patent, anybody knows what is the patent term? For how long it is valid? Anybody? Anyway, patent is valid, its patent term once granted is 20 years. And that 20 years is from the date of filing. When you file a patent, it undergoes a process. That process is called a patent prosecution. There are different stages. Initially, patent is published within 18 months. In India, there is a provision that you can get a patent published within 1 month by putting a request with requisite fee for early publication. Once a patent is published, then it is in queue for examination. It is not examined as such. You have to put up a request in specific form, that is Form 18, along with the fee requesting for examination. If at all this Form 18 is not submitted along with the fee, patent is never examined and it gets abandoned, and though it remains published, but it is never ever considered for the grant. And India, the timeline for submitting a request for examination after filing is 47 months. Therefore, please make sure once a patent is submitted, all the requisite forms are also submitted, else it remains a document which does not have any value. When it goes under prosecution, examiner more likely, not more, but most likely, they do raise objections. They do raise objections under what are the prime requirements for any invention to get a patent. There are 3. One is industrial applicability. It must have application in an industry in that specific technology domain. Second is novelty. It must be novel. It should have not been in public domain in print form or product form anywhere in the world. Not that you're finding in India and India, no, globally. Third is invention. Even though it is novel, it's something which is not known. But however, for creating that product or process or composition matter, it must have involved in personal intellect to create that. These 3 important aspects are important, are necessary for any invention to get a patent, for which you can apply for a patent. Examiner examines patent on these aspects. At the same time, you might say my invention does meet inventive feature. You have done some work to create it as a novel. There is one aspect which is called obviousness. Though invention, but that efforts put in by an individual should not be obvious to a person skilled in the art. Like we say, ये तो होता है, ये तो होना था. We did this, so it had to happen. It's not something, it has happened something which would have not happened otherwise. That is called obviousness. That is the main reason based on which most of the examiners raise objections. Whatever has been disclosed and whatever as inventive aspect claim is being asked for was an obvious. Anybody person in that particular technology domain would have done it. It's not been done by doing R&D, by doing something to show that it was not possible. There is no information in the public domain. There are three aspects. That is teaching, stimulation, and motivation. There is something in the public domain which teaches a person skilled in the art, which motivates a person skilled in the art, and which stimulates a person skilled in the art to do this thing. That's why it has been done. I rather give it an ATM. That is anticipation, teaching, and motivation. This knowledge bank, this is an ATM card to the knowledge bank, by which you rather can acquire a lot of knowledge, search for a lot of knowledge, search a lot of information, based on which you get enough ideas, enough information, enough motivation to create innovation. So therefore, based on that this has not been obvious, and one has to do it to create this invention. And once, as a result of examination, controller issues a report which is called examination report, and in other words is called an office section. In US, Europe, etc., it is called office section. Office section has to be responded to justifying that you do not agree with the controller for the obvious reason, because they cite some prior art references emphasizing that this invention is not inventive because it's obvious from this prior art, who give enough information teaching to a person skilled in the art to do it. Therefore, it should not be granted. Now it has to be responded in an appropriate manner, convincing, no, these are not relevant because of this reason. So this, once examiner is convinced, they issue the patent. Else they call for the hearing. In hearing, they listen to your viewpoint, where you justify whatever why you do not agree with the examiner. What is the difference between what examiner says vis-a-vis what you say, and try to convince, and accordingly a decision is taken whether the patent is granted or not. Once a patent is granted, please note it has to be maintained. That's the reason I'm saying obtaining and maintaining an IPR is very expensive. Therefore, one must consider generating it, which can be rather sold in the market to the industry. And maintenance fee is very high. In India, it has to be done every year. In Europe also, it has been done every year. Whereas in US, it has to be done first at the time of grant, then 7.5 years, 11.5 years. So as the patent gets older, the maintenance fees goes high. Why? Because they think you are investing money, it must be giving you a lot of business. It must be having a lot of business potential. You must be earning a lot of money out of that. That's why you're maintaining it. Therefore, the fee is high accordingly. So these aspects have to be taken into consideration while generating and maintaining IP. Once a patent is obtained, then academic institutions must have an effective strategy for out-licensing to find out suitable buyers in the industry in that specific technology domain, wherein it can be justified that how this can add value to their business. This is a very, very important aspect. Once it has been done, it has been, because as I told you, please note, patent is a jurisdiction wise. It's not that you have got a patent and you have got a rights at global level. No. There are two ways to have wider protection of your invention. If you file a patent, there is a law under Section 45. Once an invention is done in India, first patent has to be filed in India. You cannot file it outside India. However, there's a provision you can file outside India after informing and getting an appropriate permission from Indian Patent Office by submitting respecting form, which is easy. If for some reason you don't do it, you file directly outside in India, anywhere else, US, Europe, etc. Yes, you can file. But later, if you file in India at national phase entry in India, you may be asked question, does it comply Indian patent law that the patent has been done in India? Invention has been done in India without any prior permission. It has been filed outside India and it can be rejected. Therefore, one must consider, if at all, and for any invention, it is necessary that first you file in India, or if you do not wish to file in India, take a permission from the Indian Patent Office to file it outside, and later you can file in India. Yes. As per the law, within 12 months from the filing, if you want to file anywhere else in the world, within the 12 months you have to file anywhere else. After 12 months, if you do not file, then it becomes a public document, public property, and you do not have right to file anywhere else. Though you may get a patent in India, it gets protected in India, but everywhere else outside India, it is a free property for anybody to use without any infringement. Therefore, please make sure that this is complied with. Or else, there's a provision. There has been a patent cooperation treaty in Paris, based on which it was decided any WTO member state, can file a WTO patent application, PCT application, that is Patent Cooperation Treaty application, which is filed. WTO has got a WIPO office in Geneva, which is called World Intellectual Property Office, which is a offshoot of WTO. WIPO has got a provision based on Patent Cooperation Treaty, Paris Patent Cooperation Treaty. Within 18 months after a patent is filed in a specific jurisdiction, a PCT application can be filed with WIPO. Once a PCT application has been filed in WIPO, then the window for filing anywhere else increases from 12 months to 30 months. Please note it. Then there is a provision that you have got enough time to think over if there is a need to file anywhere else, and that timeline is 30 months if you file PCT application, else it is 12 months. In PCT application process also, you might have seen WO application, which many people assume is a word application, word patent. That is a PCT application, and that is only in application stage, and it's not a granted, not enforceable document. It's never granted. It remains only in public domain, gets examined, gives an idea to an innovator about its patentability, because it is also examined by authorized search authorities. There at moment are 5 search authorities globally, and effective 2019, India has also become a search authority for PCT applications. Their examination report is issued, which is called ISR, International Search Report, where it is ascertained whether the invention for which PCT application has been filed does have merit based on which it can be considered for grant or not. That search report is certainly viewed by most of the patent office at global level, wherever this is filed, as a base, and then it undergoes prosecution process at different jurisdictions. So is it clear? Any question on that? Okay. Now, once a patent has been granted, it has to be maintained. And as I told you, academic institutions must have an effective strategy for out-licensing. When you say out-licensing has got different ways: exclusive and non-exclusive. Exclusive is that you can give full rights to a licensee in respect of its claims that he rather buys out the patent exclusively. If at all there's a provision to enter in other national jurisdiction, that can also be part of the agreement. Whether you have a right or licensee, you give all the rights to him. Accordingly, price is decided. Price can be one-time price, or price can be some divided in two aspects: one-time price and the royalty. Wherever this technology is being used in an industry, royalty on that based on the sales, net sales again, that depends on case to case. We cannot generalize it. These are the two aspects which has to be considered for out licensing. And then sometime what happens? You file a patent in India, you get a grant. You do file patents outside also. You get a party in India who wants to get a license only for Indian jurisdiction. You have a provision to, if at all you have not filed, if you ascertain potential of your invention and different jurisdictions, you can find a different licenses in different jurisdictions. There's an ample of opportunities that you can get a provision of filing patent in different jurisdictions and get licenses accordingly, and lot of great potential that you get a lot of money in return, which can assist in further innovation, further IP creation, and likewise. So this is all related to patents. How to get a patent, the process an invention undergoes before a decision is taken, is granted, and also what are the basis, what starting point which provides an opportunity to identify the potential projects based on which one can create patent and which has got a ready buyer in the market in that specific technology domain. Further, I would like to emphasize on the aspects of enforcement. I tell you, it's very imperative. One has to keep eyes open. If you're not able to find a potential licensee and your patent is granted, you have to do introspection. You have to do great search on products where this technology can be used, and through reverse engineering, try to find out if claims are being practiced for creating that product which is there in public domain, which is there in the market. And then you have to, because licensing is of two types: vertical licenses, amicably licensed, and infringement licensing. If sometime you want to give for the national interest your technology to the industry, that is called voluntary licensing. That voluntarily you are giving it. One is licensing, out licensing based on an agreement against which you get a price, one time or royalty. Third is that party is using your technology without your information. There you have to go through the legal process where you have to find it out and approach the party that they are infringing your patent, and you have to, rather through legal process, you have to force them to get license of your patent. These are the different methods by which one can make use of the inventions which have been created by these academic institutions. And any question on that so far? Please feel free to ask any question. Hello? Am I audible? Hello?
Yes, sir, you are audible.
Is there any question?
No,
Because
sir.
if you thought, no, my point is we have covered how to get a patent and how to make use of the patent for its licensing to the industries, that is the IP management. If at all anybody wants to know specific information and specific aspects, please tell me so that it can be done. That'll be more useful. Please feel free. No? Okay. Now I will share with you what is patentable in general. I would like to ask you one question. You know turmeric, haldi, which is used as for medical applications in day-to-day life. Can anybody say, can one get a patent on haldi as a product?
No, sir,
Why?
because it is freely available in nature.
It is yes, because it is a creation of a nature. It is not a creation of a human intellect. It is a creation of a nature. Similarly, I ask you one question. Supposing you're walking bare feet in a garden on a grass. You are having this ankle ache. You all of a sudden find that after you walk couple of days, you are relieved of the ache, of the pain. Is it not something good? Can you get a patent on the grass which is responsible for relieving you of your pain? Please say.
No, sir, it is not possible.
Yes, it's not possible, though your finding is new. Your finding is new, but the process by which you found this thing is already created by the nature, not by the human intellect. However, if you find out what is the process by which you are getting a relief in the pain, which involves certain inventive feature and some human intellect, on that aspect you can get a patent, not on the gross as a product. Similarly, if at all, Ayurvedic, the herbs, there is a case study wherein a product was isolated from a plant, and that product was responsible for its medical use, which was relieving, which was rather responsible for curing that specific disease. Similarly, no one could get a patent on that chemical product which is isolated from the plant, because that product existed in that plant. That product was not made by a human intellect. However, one get a patent on process of isolating that product from the plant if it is a novel process, if it is an inventive process. At the same time, if at all that chemical compound which is isolated from the nature is chemically modified, and that chemically modified compound has got additional benefits vis-a-vis whatever natural compound does alone, then one can get a patent on that modified new molecule which is based on the natural product, because human intellect is involved in creating that new molecule which has got additional medical features in respect of side effects or likewise. Clear? That is how, in light of this patent law, it is imperative to plan your strategies for innovation and maintaining and making use of your intellectual property in the interest of the institution and innovations. So I think that's what I had planned to share with you all. Patents in respect, IP in respect to patent, because in your case it is the patents only which has pertinence. Other aspects of the IPR like trademarks and copyright doesn't have any relevance to academic institution. Am I right?
Yes, sir.
So this is what I had planned, and I hope it's useful. And you can ask me any question if you have. I did not go by section-wise patent law, because section-wise patent law is not of much use to the scientists. That is more for the legal fraternity. I have primarily focused on whatever is most relevant to the R&D. A scientist who has to create IP, what he or she should do while creating IP, while planning for new R&D projects, which can be really useful and assist in creating rather provisions and for more innovations, and likewise. And whatever is being practiced by academic institutions which have got a big, I would say, financial verticals inputs through innovation. Like I tell you, Wisconsin University and California University, they have been selling their patents worth billions of dollars to the industry. 2-3 patents I told you, one arthritis patent was sold for $1.7 billion by university. And recently there had been case study where one automobile sector, the party had been using the technology, and university filed a suit against them, and $760 million they recovered from the industry for infringement of the patent. That is the potential, that's the value of the patent, which probably is not being realized in India by the academic session, by the academic institutions. You must plan at the beginning itself to create a product which has got a buyer in the market, and which in direct manner adds big value to country's GDP and job creations, and in every aspects for the development, national development. So that's from me. If there's any question, you're all welcome. I hope my talk didn't prove to be a sleeping dose after lunch for the audience. Hello? Hello?
So there is a question in the chat box. Can you please answer that?
Where is that question? I can't see that. Just, where is chat box? Present now. Turn on application. There is I can't see chat box. Where is chat box?
Sir, on the Google Meet page on the left side of the time, you can see a chat box button.
Just hold on. Application.
एप्स की जगह पे पूछो वहां तो नहीं
नहीं just hold on let me Hello? Hello, can you hear me now?
Yes, we can hear you.
I'm not getting chat box. I'm sorry, it went off again. I had to come back. I'm not saying. You asked me the question. I would like to answer that, please.
Okay, I'll read the question.
Yes, please.
If one has to file a patent at international and national level,
Yeah.
then do we have to file up the patent separately at international and national level?
Yes, please. Because patent filing is jurisdiction wise. As I told you, I rather knew this kind of thing. That's why I elaborated on that. If at all you're filed in India, that is enforceable and will undergo prosecution only in India. If you want to file anywhere else in the world, you have to specifically file in that specific jurisdiction. And for instance, let me tell you, and I told you, when you say international level, PCT application is not a patent which is enforceable. That rather provides you a provision to have a wider window of 30 months during which you can go into any national level. It has to be filed specifically in each country separately. And as furthermore, I would like to elaborate one aspect on this. Many people might think that if you file a patent in Europe and it is applicable in all European states. No. All the European states have jointly got a European Patent Office, wherein if at all you are interested in filing in different countries in Europe, then you go to Europe. If you want to file only one country or two countries in Europe, then there is no point in going to European Patent Office. Why? Because once a patent gets granted by European Patent Office, please note, though granted, but it's meaningless, is a piece of paper, piece of scrap, unless and until it gets validated in the European member state where you want protection. Though it will not undergo prosecution again, once granted, it's an administrative process to validate that granted patent in respective European states, where you will get a different patent number of those respective papers, respective European state. Then only it become enforceable, not otherwise. Otherwise, it's a piece of scrap which does not have any value, though granted. Clear?
Okay, so there was another question that
Yes, please.
if the patent applied to the country, is
Yeah.
the patent applied to that country where it is registered?
Yeah.
And so if similar patent is filed in some another country,
Yeah.
then will it be approved?
You remember that I told you novelty, inventiveness, and subshoot of inventiveness is obviousness. These are the primary factors which are taken into consideration during prosecution time before a decision of rejecting or granting a patent is taken. Therefore, if a similar patent, what is disclosed in that patent, which already exists, vis-a-vis a new patent which you file in some other country, it depends. And if at all you can justify whatever you are doing, it does not enable anticipation, stimulation, or motivation to a person skilled in the art, and it required a special R&D efforts to do it. Therefore, whatever is known in other country is not relevant to it. It all depends on how prosecution matter is taken into consideration. At the same time, let me tell you another thing. Many times what happens, you find a patent which is in prosecution or granted, and which is more pertinent to your question, and you find that same thing is already known in some other country, it is in public domain. And it is possible that controller or examiner might have not captured that prior art, which you have captured, and grants it. Then in the law, there's a provision. Pre-grant opposition, if at all the patent has not been granted but is published and is under prosecution, you can write to the controller, to the patent office, please take into consideration this patent, this prior art reference. It's not only patent, even published document, even publication also. They are relevant as a prior art. Take into consideration while examining this patent, and therefore, in my opinion, it should not be considered for grant because of this reason. If for some reason patent has been granted and you are convinced that whatever prior art reference you have cited, which may be from any part of the world, not in India, but any part of the world, are product which is based on that technology, which is there in the public domain, you can go for post-grant opposition. And as per the law, pre-grant opposition is at a controller level while examination. Post-grant, if within 1 year from the grant, it is at controller level, that you can put a post-grant opposition. If at all it is beyond 1 year, then it is there is a board, intellectual property appellate board, which comprises a team of legal experts and technical experts. It has to go to them, and they will take into consideration your appeal of post-grant opposition. There are provisions in the law. I hope it answers your question. Does it answer your question? Hello?
So I hope it has answered your question, Narendra Kumar. If there are any questions, you can ask in the chat box or directly
Yeah,
ask.
no, I got the chat box now. Yes, I got the chat box. I could get hold of the chat box. Yes. There, I don't find any other question. If there's any other question, you're welcome to ask. I think you have got my email ID. You can give my email ID to the all the audience members. If at all they got any query or they want to seek any clarification at any point, they can write to me. It's my pleasure and privilege if at all I can answer their questions.
Okay, so I think there are no more questions. We'll quickly summarize the today's session. So please,
Yes, please.
summarize.
Yes, please. Yes, please.
Good evening to one and all present. It's my pleasure to thank our eminent speaker, Dr. C.K. Sehgal, sir, to give us a brief insight about what is intellectual property rights, history of patents and kinds of intellectual property, which are industrial property and copyright property. So you briefly explained the two and the objects of intellectual property. What are the forms of intellectual property rights? Then you explained the protected intellectual property, informed about the level of ordinary skill in the art and the factors. You then explained the origin of IPR patents and what can be actually patented. You gave us an example of haldi turmeric, and you explained that it cannot be patented as it is a product out of traditional knowledge. Then you gave us information about the history of patents, the patent system timeline, and what rights does a patent owner have, who may obtain a patent, life of patents, primary requirement for a patent. Then you briefly explained the Indian patent law and the development of patent law in India, and introduced the IPR acts and rules in India for patents. Thank you, sir. The overall session was very informative and brainstorming. Thank you for this wonderful session.
Thank you very much. So we can conclude this now?
Yes, sir.
Thank you very much indeed. I rather must express my gratitude for very patient hearing, and I hope it didn't turn out to be a sleeping pill after lunch, wherever I tried to make it an awakening pill. Thank you very much. Chalo.